classified as a first felony offender, offense forcible rape. Sentencing date May 17, 2005. Sentenced to a total of 35 years. Parole date July 16, 2022. Good time not eligible. Full term July 15, 2037. Is this information correct, sir?
Yes.
Thank you. Mr. Wise.
Yes, ma'am. I just want to say this right straight up before we get started. I see there's a Miss Kelly Wise, a victim's family. I just want to say I'm no relationship that I know of to any of this family, so I just want to get that out of the air right now. On 2 of 21, you had a 21F. I just want you to know that's a problem for me. Anytime you have a disciplinary write-up in the last 12 months, but with your case, you've had a couple of these 21Fs I see in your jacket. But as I go along, you've had 3 disciplinary write-ups in a pretty short time that gives me a problem. Mr. Clarkson, have you took the sex offender program, all 4 phases of it?
I did. I finished 2 of them. On the 3rd one, now I got transferred, and I've been moving around since then.
Well, I just want you to know you need to be working on those programs there. And at this time, I have no other questions because of your disciplinary write-ups. It gives me a problem. I see no one else to got any questions there. If it would, Miss Tammy Jump, the assistant DA, I can't hardly see you. Don't have a lot of light in there, but if you would, you want to go ahead and speak at this time?
Can you hear me?
Yes, ma'am, I can hear you. Speak loud and clear.
Okay. My name is Tammy Jump. As y'all have already stated, I'm the first assistant district attorney for the judicial district, which includes this parish and the parish. I've been the felony prosecutor here for 21 years, and I had the pleasure of knowing the victim in this matter, Miss Mooney, who was 89 years old when this rape occurred. My first boss is the one who prosecuted the case, and I sat second chair. The defendant's explanation of some evidence that was found at the scene was that people plant things. He never admitted to the crime to law enforcement. However, we had irrefutable DNA evidence that he had committed the rape. Because of Miss Mooney's age, we decided to take her testimony in a preliminary hearing, which actually took place about 2 years before the trial. And she had to relive that night in front of the defendant, the judge, her family, and everybody else that was in the courtroom that day. She was a very strong lady. She reminded me a lot of my great-grandmother. And we ended up picking a jury on May the 16th of 2005. And the morning of May the 17th, Miss Mooney and her family requested that the state offer an amended charge of forcible rape and the sentence that he ultimately got, which was 35 years. I spoke to Miss Mooney alone in my office that morning about their request, and she was still very strong, but she did not want to relive that again in open court. There's a reason why, in my opinion, that our laws protect the children and the elderly. There's a reason why the penalty for doing this to one of those protected groups is so much higher. And to me, it's because they can't protect themselves. Most of the time they're weaker and than someone else might be in that same situation. I believe if we had tried the case that Mr. Clarkson would actually be serving a life sentence. So in my opinion, 20 years is not enough, and the state strongly opposes his release. Thank you for letting me speak.
Thank you very much. Mr. Clarkson, anything you have to say to the board before we vote?
Well, consistent to the victim statement, it was an officer that came to the scene, and he apparently didn't see any sign of no crime, and he left. And when he apparently asked Mrs. Mooney what happened.
Listen to me. We're not here to try the case.
Right, right.
We're not here to try the case. Anything you had to say on your behalf?
Oh, well, I'm sorry that happened, and most of all, I feel like if I had in control of it, it wouldn't have happened. And I did the best I can being incarcerated to overcome that scene where they involved me. So I'm just wanting to get out of here and live my life to where I can make
Okay.
citizen.
Let me tell you something how to get out of there. First of all, you don't get no disciplinary write-ups. You had 3 Class D write-ups in about the last 30 months, and 2 of them with a 21F. Today, my vote is to deny because your disciplinary actions. Also, you need to complete all 4 phases of your sex offender treatment program. There's strong law enforcement opposition, also victims' opposition to this case. Thank you very much. At this time, Mr. Roche be voting.
Thank you, Mr. Chairman. Mr. Clarkson, based upon your disciplinary issues, as Mr. Wise said, 3 Class B write-ups in the last 30 months, last one only 12 months ago. Poor institutional record, law enforcement opposition. The DA's office is adamantly opposed to any release, and you have incomplete sex offender treatment. My vote is to deny your request.
At this time, Ms. Bonnie Jackson.
Right, Mr. Clarkson, for the same reasons as my colleagues, you still got some work to do, quite a bit of work to do. I see that you've taken victim awareness, but you might need to take that again because I don't think you really understand the magnitude of your crime. You have not completed sex offender treatment. You have a poor disciplinary record. You have strong opposition from law enforcement and the victims, and you have no transition plan. So my vote today is to deny, but I encourage you to continue to work to try to, come to terms with this case. You're not there yet, but my vote today is to deny, and good luck to you.
Okay, thank you very much. At this time, the board has voted to deny with the same conditions stated. Thank each and every one of you.
I have the Angola rule book right here, so we'll go over what that write-up is about. We haven't had a 21F before, but first let me just touch on this case. There are no documentation, so I can't, unpack it in that sense. But first time ever seeing this DA, so it's nice that she did show up for at least one 89-year-old victim, and that's just absolutely terrifying to think. 89 years old. And, it's like, I think, a known true crime thing that those who do this to older women are even exceptionally or uniquely more dangerous for whatever reason. But the idea that to make it to 89 years and then have someone do what they did to you, and it's proven through DNA evidence. So it's just unbelievable. Jim Wise, when he started yelling at him, I was kind of in my zone and I jumped. I actually got startled when he lashed out and said, we're not trying the case today. And it was like one of the few times that I actually kind of enjoyed Jim Wise's hearing. I know his bar is set very low, that it doesn't take much for me to say that, but he seemed to just kind of, he just like drilled in there, and I don't know, it was interesting. Also interesting that he mentioned that he wasn't related to the other Wise. So this is he's probably going to be in there for life, this guy. So here is the actual rule book for Angola. And so he got a 21. So 21 is always a sex offense whenever you hear 21. And then there are different, A, B, C, D, E. So it's non-consensual and or consensual acts involving offender on offender or non-offender on staff or non-incarcerated persons are strictly prohibited. Contact by any other offender, any person without the person's consent, or a person who is unable to consent or refuse through coercion are strictly prohibited. There is no consensual sex either. So really any type of is a write-up. That's the word I was looking for, write-up. So there's A, B, C, D, E, and he got F. Other prohibited sexual behavior, offender on offender, offender on staff, or non-incarcerated person, which is always interesting that they feel the need to bring that up. It's really like, no offender shall make sexual remarks, gestures, or sounds, flirt, exchange personal items, etc. Talk about, you ever see a legal document with the word etc.? I mean, I don't, you know that this rule book is written for a prison when you can get away with a legal document saying etc. It's like, let's make this as vague and as encompassing as possible. Let's just throw in the word etc. Because who's gonna fight? Who's gonna fight? I guess the ACLU would take something like this up, but anyways. Or make sexual threats in conversation by correspondence or telephone. So it's really, this offense F seems to me actually to be less serious than the other offenses. This is more of doing, not actually doing an act, but more of an action, like sexual remarks, flirting, whistling, at I guess a female prison guard would constitute a 21F. Versus there are much more, severe cases that we've seen. So I think to get an F, you probably, like D is much worse. That would be contact or attempted contact between your it's like full on, right? Attempted penetration. That's D. G is overt display of affection in a manner that may elicit sexual arousal with anyone prohibited. F is other prohibited sexual behaviors, offender on offender, offender on da-da-da. No offender shall make, oh, I just did that. What am I doing? Sometimes it's that time of day when I'm just not, my brain's not fully on. A is the worst. So 21A is non-consensual. Offender on offender, contact between including penetration. However, slight contact between that. You're right. So I think A is the worst. B is abusive sexual contact, but not limited to intentional touching or through. I guess B is second to worst. No offender shall assault another offender by force or threat of force. So anyways, it is terrifying. It's nice to see that the ADA showed up. We haven't seen it for any other case. Why is that? I don't know. But anyways, thank you, Richard, for the info. And with that, I'll let you go.